Can I have the Commonwealth identify herself in general?
Good morning, good afternoon.
Yeah.
My name is Lisa Beatty. I'm an assistant district attorney, and as I said earlier, there are various assistant district attorneys assigned to the various different prosecution teams who are present in court and available if necessary.
Okay, so just for the record, we have this case is Commonwealth versus Myles King, 21-320. We have Bianca Ciancio, which is 22-265. Giovanni De Los Santos, 22-267. And Mr. De Los Santos is here?
Yes.
Okay. We have Sean Johnson, 22-268. Mr. Johnson is present.
He has a purple shirt.
Okay, we have Brian Walsh, which is 23-CR91. And I think those are all the cases that we currently have on our docket for today.
It's not clear to me if Mr. Walsh is present on Zoom or if his presence is waived.
First of all, the sheriff's office is there, and I could tell the sheriff's office to get Mr. Walsh, please. Mr. Tipton and Ms. Porges are on Zoom, and I could have them identify themselves in just a second, but I would like to see Mr. Walsh first.
Okay, coming at you.
Great, thank you so much.
Okay, so we have Ms. Beatty now representing Mr. King.
Good afternoon, Your Honor. Rosemary Capiccio on behalf of Mr. King as well as Mr. Johnson.
Okay,
Good afternoon, Your Honor. Nicole Capiccio on behalf of Mr. King and Mr. Johnson.
very good. Okay,
Attorney Krauske on behalf of Giovanni De Los Santos.
all right, Mr. Krowski.
Attorney Joseph Cataldo on behalf of Bianca Ciancio.
Okay.
And
Mr.
Judge,
Cataldo?
Mr. Walsh does appear now on Zoom, and could I have his counsel identify themselves?
Good morning, everyone. Good morning, Mr. Walsh. Kelly Porges on behalf of Mr. Walsh.
Okay.
Good afternoon, Judge. Larry Tipton for Mr. Walsh.
All right, Mr. Tipton, it's a little hard to hear you. I don't know if you're distanced from your microphone or what. I could hear Ms. Porges well, but not your introduction, but we heard you well enough for the introduction. All right.
All right, I'll speak louder.
Okay, what is our current status?
Your Honor, we appreciate the time that the court has provided to the Commonwealth, and I think we've made some significant progress in resolving the issues at hand. Through the communication and dialogue with the U.S. Attorney's Office, they've provided us now with a letter outlining their position.
This is the letter dated August 5th, 2025?
Yes.
It was provided to me in a sealed envelope with a note that says, sealed, do not open without court approval. I opened it and read it. I saw nothing in there that should be, that would be confidential. Is there any reason it shouldn't be filed on the public docket?
There's not.
Okay.
That was provided to counsel in all of these cases, and I think that probably was, out of an abundance of caution, provided to you that way.
All right, so that'll be docketed in each of the dockets. Okay.
In addition, and as referenced in that letter, and similarly to what happened in September of 2024, outside of the federal protective order, the U.S. Attorney's Office has now provided all of the Proctor communications that were initially provided to the parties in the Reed matter. I can tell the court that it's 168 pages and that it contains many of the chats that were discussed during the Reed trial, as well as chats that we have discussed in previous proceedings. We have provided counsel in all of these cases, and we will in other cases as well, if necessary, with a protective order, and that we would ask the court to endorse it, and then we can provide those chats to counsel. We are aware that defense attorneys are taking the position that the Norfolk District Attorney's Office needs to review the additional materials, the materials that have not been provided outside of the protective order to the Norfolk District Attorney's Office. And with that knowledge, that their position that we need to do that, we have taken the additional step of filing a motion to intervene and seeking relief from Judge Casper. That was done today. We filed under seal, given our understanding that it's not a public docket at this time in the federal court.
You have a copy of your filing for the court to review.
I do not at this time.
Have you shared it with defense counsel?
We have not.
Okay.
I can tell the court that we are making requests, including asking permission for the Norfolk District Attorney's Office or outside counsel to review the materials. And we are also asking that or in the alternative, we are asking that we be able to retain the materials so that the defense attorneys can pursue their own avenues of obtaining the materials through Freedom of Information Acts or the 2E process. We've reached an agreement with the U.S. Attorney's Office that our filing tolls the return and destroy date, and we have...
Judge Casper agree with that?
I don't know that she's seen our filing at this time. I don't know what her understanding is.
When the U.S. Attorney's Office agreement is no good,
Well,
it's what Judge Casper thinks her ruling means.
and so what I'm telling you is based on the representation from the U.S. Attorney's Office and absent a ruling from Judge Casper, at this time, we will not be returning or destroying the documents.
Oh,
So as the court, I'm sure is aware,
So if I understand correctly, Judge Casper's ruling runs until
Commonwealth.
the 17th of this month, so that falls on a Sunday, so it would fall on the 18th of this month. You filed today,
Yes,
which gives us a 5-day window, basically, or 6-day window. If Judge Casper doesn't agree with your tolling idea, well, if she doesn't agree with your tolling idea, that's a real problem, right? Because that means things expire on Monday and have to be destroyed or returned on Monday under her order. And if she does agree with your tolling and then ultimately doesn't extend or doesn't makes a decision on the merits of your motion and doesn't allow you to intervene or whatever it is, then we only have 5 days. If she agrees with tolling and doesn't agree on the merits, you only have 5 days to do whatever I might order. And we don't know when she's going to act.
Your Honor, the last time that we were in a somewhat similar procedural posture when the U.S. Attorney's Office filed their motion, there was no disagreement that the filing of that motion told the order.
Mm-hmm.
So that's why I feel reasonably confident that we can anticipate that we will be able to litigate this matter in the federal court. But regardless of that, I want to be clear that we have obtained additional materials during the time period that we've been working on this. And certainly, as outlined in the letter, the most substantive and relevant and probative issues to our Rule 14 obligations.
Okay. So that's the current status from your perspective.
That's the current status from our perspective.
And what are you asking me to do?
So I'm asking you to take no further action with regard to the global matters. I understand that there are individual defendants who are asking for the court on their individual cases to make particular rulings. I know that there's at least one filing in one of those cases. And I think that you could, I don't know whether or not the courts had the opportunity to review our opposition. I think we filed.
You're talking about the Walshe matter, the motion to dismiss in Walshe, and your response. I did receive both and read them both. So you would have me take no further action and schedule no further hearing? Or do what? I mean, what do you think I should do in terms of schedule, given what you filed with Judge Casper? Do you know if she's around, if she scheduled the hearing, if she, do you know what her schedule is?
I can tell the court that we only very recently filed. So
Okay.
I don't think it's realistic to think that she's aware of our filing or has any intention at this point in time as we are speaking.
All right. I mean, I'm a little hamstrung here because I was encouraging you to do this weeks ago and encouraging the defense counsel to also seek to intervene in the proceeding, a while ago, and it only happened now, and we have a very short amount of time.
I understand that, but I do think that we've achieved an awful lot during that time period.
I
and
think
so it
this is
wasn't
Walshe.
wasted time. And I think that what we have obtained is probably was more efficient than handling it in any other manner, quite frankly. And I don't know what defense counsel's position is at this point in time. I don't know whether or not any of them has filed any pleadings in the federal court. But if the court wants to pick another date, we can do that. But I don't think that it's necessary to continue on the week by week kind of path that we have been on.
If I don't continue a week by week, as soon as Judge Casper rules, we have a 4-day or 5-day window. I suppose I could enter an order today, which is contingent on what Judge Casper might do. There are a lot of things I could do, but it would be very if this, then that, which is problematic for me in fashioning a suitable remedy.
I understand that. I do think that, you know, and this court is aware that there are, that the federal law is significant in this regard.
But so is the state law. And regardless of what the federal law says or doesn't say, you've had custody and possession of these records for more than a year. And this is, you know, we've talked about this already. It's at the very end of the time that this is all coming to a head. And leaving aside the question about whether you control the records, which is the operative language in a lot of the filings, you clearly have possession and custody, and that's what the feds are worried about. Rule 14 says what it says, and our constitutional interpretive case law says what it says in terms of the obligation on prosecutors to review and disclose that type of information. So the court has significant remedies available to it, and that don't involve ordering you to do something in violation of the federal law, okay? But there would be consequences on you and your prosecution of these cases if you did not comply with your state constitutional requirements or your Rule 14 requirements with respect to the material that's in your possession and custody.
But that's why we're acting in the manner in which we're acting, Your Honor. And I want to be clear, as the court now is aware, the order itself prohibited this discussion prior to only recently.
I don't know that. You've given me a December 2024 order. I don't know what was in place in February. I don't know what I think there was a date between February and December where there was another order. I haven't seen those orders.
So
I mean, I don't know why you can't give me a copy of what you filed with Judge Casper, or give to defense counsel, to be honest. The fact that it's a sealed proceeding, it doesn't mean that you have to file everything, you have to keep everything that you file in that proceeding under seal.
I'm relying on the advice of our counsel, and we have repeatedly asked for those previous orders. We have been told that those previous orders substantively are identical to the most recent order, that the reason there were multiple dates was if they provided for different people to sign the acknowledgement. That's all the information that I have.
Have defense counsel sought to subpoena the information from defense counsel in the Reed case? Because all of it was turned over to them.
I did speak to one of the attorneys in the Reed case, Your Honor, asking for that information. It was that attorney's position that the document was under seal and that they couldn't give it up voluntarily. And they didn't know what they would do in response to a subpoena. But that's the information that I got from the judge.
Okay.
They don't think that they think that they're bound by the order that they signed.
Okay. Well, all right. Well, you didn't subpoena them. It's not framed. It's not, the issue is not joined. The issue.
If we have a new hearing date, I'm happy to subpoena it.
Mm-hmm.
But I don't have a subpoena for this court date because I thought that might be an abuse of the subpoena power because we weren't going to actually. No.
I agree with you, but we were not going to have evidence today. All right. Well, let me hear from defense counsel as to what one or more think I should do.
So, Judge, on behalf of Mr. King and Mr. Johnson, I'm asking that you take action on our underlying motions that we filed for relief regarding the federal materials in possession of the Commonwealth. I'm very concerned that we have 5 days. I was concerned when we were here last time that time, the clock was ticking. I know the court was concerned. I know the Commonwealth was concerned. But the bottom line is that if this doesn't go the way the Commonwealth anticipates it will, then these documents are gone forever, and we'll have to file additional motions as to what the court can or should do under those circumstances. So we're asking the court to act on our motions in order the Commonwealth to review the evidence that they have in its custody. In the alternative, we're asking that if the Commonwealth declines to do that, or the court declines to enter such an order, I'd be asking the court to dismiss the cases against my client, because he cannot get a fair trial without the opportunity to review and analyze the information that's been in the possession of the Commonwealth since February of 2024.
Okay.
Judge, Attorney Krauske on behalf of Giovanni Della Santos. Just one suggestion, is there, having practiced in federal court and still currently practicing in federal court, is there any reason that the government cannot make a call to Judge Casper's session clerk right now and find out whether or not it has been docketed and whether or not there's been a hearing order?
I'm sure it was filed by Pacer. I'm sure it was on Pacer and it's been docketed. There's a representation already that it's already been filed. But obviously I would like to know when Judge Casper is likely to see it and review it. She may be on a 2-week vacation hiking in Nepal. And so I don't know.
And that's sometime, I just know anecdotally and empirically, that's information that the session clerk might be able to reveal that it's being reviewed. I understand the position that going forward, we don't need a court date every week, but certainly the posture right now, I think we need a weekly court date. So I think that
I agree with that. I agree with that, and I'm surprised the U.S. Attorney's Office didn't join in a 30-day extension. What's troubling to me is the U.S. Attorney's Office's position in the letter to Attorney Beatty, that they're not going to seek a further extension or further amendment of the protective order. So they seem to be saying we've done as much as we're going to do. Now, the information that Attorney Beatty is sharing with us now, or sharing with me now, maybe you folks knew before, that they've agreed to tolling. And again, we don't know whether Judge Casper is going to agree with that, but they've agreed with the idea of tolling, even if it's not an extension, just means we have that 5-day window that's preserved. And so that informs me about when I need a next hearing, unless we can get further confidence that we're going to have enough time to deal with this.
well, I think we need a hearing on or before Monday. Just so it's clear on the record, on behalf of Mr. Della Santos, I'm joining the request that all Rule 14 discovery in the possession of the District Attorney's Office be turned over to Mr. Della Santos, irrespective of any other order from any other court immediately.
All right. Any other counsel wish to be heard? Mr. Cataldo?
Yes, thank you. I think we need another date before the federal court, once they act as Judge Casper acts. We need another date, a short date, and I think it goes without saying that we should order the District Attorney's Office to comply with Rule 14 and go through all of it and meet their obligations to us.
I don't need to order the District Attorney's Office to comply with Rule 14. They have that obligation already. They already have the obligation under Giglio and Brady and related cases to produce information in their possession and custody, which are exculpatory.
They're complying with that.
Well, that's a question that I have. Okay, that's a question that I have in connection with the Walshe filing with respect to the opposition of the motion to dismiss in the Walshe filing, and we'll get to that. But I don't need to enter that order because that is already their obligation.
Can I just make a couple additional points?
Yeah, I was thinking I might hear from Mr. Tipton before, but go ahead. I hear you, and then I'll hear from you.
I think Ms. Cusick is going to represent the Commonwealth on the Walshe case.
Okay.
She had filed the pleading that's more specific and responsive to the multiple pleadings in the Walshe case.
Okay.
So, I'll let her chime in at the end, but I do want to note that defense counsel is orally moving to dismiss. The Commonwealth is not on any notice of that, so I would ask you not to take any action in terms of dismissal at this time. I also would note that no counsel has cited a case that outlines this particular procedural posture and how it interplays with Rule 14. And I appreciate that the court is saying that you don't need to order us to comply with Rule 14. And I don't mean to be disingenuous when I say you don't. We take this seriously.
No, I understand that, and I'm not suggesting that otherwise. I'm really not suggesting
I know
otherwise.
Defense counsel isn't either.
Yep.
But this is a big deal.
Yep.
what is being contemplated here. And to throw these sorts of terms around these are important issues for the defendants. These are important issues to the Commonwealth, to the victims, and to our whole process. And this office is committed to and is continuing to work through these issues.
And I appreciate that, and I appreciate the way defense counsel's handled it, and that's the reason why I'm taking it in sort of an incremental way. I understand the sensitivity of it. At the same time, I'm trying to get us to a point where it is a non-issue, okay, where we can be satisfied that the documents, that we don't have to parse control versus custody versus possession, okay, and what that means under Rule 14 in this particular kind of a case. Because I'm not sure that there are cases that we'll find, certainly not in Massachusetts on this topic, and certainly not under Rule 14 as it's been recently amended. So I think we need to know what next steps Judge Casper takes, and we need to respond accordingly. And give Judge Casper the opportunity to address these issues, understanding their sensitivity.
Can I just respond briefly? Sure. I know we talked about, at least the Commonwealth talked about a response that they made in the Walshe case. They haven't responded to either of the motions that we filed on behalf of Mr. King or Mr. Johnson. I don't have a copy of their response in Mr. Walsh's case. So to the extent that they've known about these motions since they were filed back on, July 18th, 2025, they've yet to respond and oppose it in any way. And now are we supposed to, the defendants in this case, are supposed to keep track of what's going on in Walshe to know the Commonwealth's position?
I understand that particular predicament, and I am happy to set a schedule for the Commonwealth to respond to your motions. I don't think I'm prepared to address the Walshe motions just yet, but I want to hear from counsel on them. The issue that I raised, that I had a question on, I'll see counsel on the Walshe matter if they wish to address the court separately. Mr. Tipton and Ms. Porges, I think you're up. I have a motion to dismiss or request for alternative relief. I'm inclined to go gently on this issue and see what Judge Casper does in terms of either giving us additional time to consider this. Let me just ask again, Ms. Beatty, to say exactly the relief that was sought from Judge Casper. One, besides leave to intervene, what else did you ask for?
We asked for permit modification or a court order that would permit the Norfolk District Attorney's Office or outside counsel to review the materials. We also asked that we be permitted to retain the materials for a period such as 6 months so that defense attorneys could pursue their own avenues of obtaining the materials. And I just have 1 minute. We asked that the court toll the destruction date in the protective order until after the issues, bless you, until after the issues raised in the motion are fully resolved. And as I said, we asked for oral argument. And I'm happy to ask our counsel whether or not we can share these pleadings, but I'm not prepared to share them at this time.
At the appropriate time, Judge, I'd like to be heard briefly.
Yeah, hang on 1 sec, Mr. Tipton. So the second to last paragraph of the first Assistant U.S. Attorney's letter, dated August 5, says, in the United States' view, it would be inappropriate with the Norfolk County District Attorney's Office or Defense Counsel in the other matters to seek to intervene in the U.S. District Court matter and to move to amend the protective order.
Yes.
That sounds like, other than the agreement with respect to tolling until Judge Casper can decide what she needs to decide, you're going to be faced with an opposition by the U.S. Attorney's Office to your motion to intervene.
I agree with that assessment, Your Honor. And we took the steps that we took, notwithstanding the position of the U.S. Attorney's Office, and we reached the tolling agreement after this letter. So my point that I'm trying to make is, notwithstanding their substantive point, I do not think that they are trying to put this court or this district attorney's office in the position of violating either a state court order or a federal court order.
Okay. Mr. Tipton.
Thank you, Your Honor. I mean, I heard you say you were,
Hang on 1 second. Can everybody hear Mr. Tipton? I have difficulty hearing him. Well, hang on a second. Let's see if Mr. Tipton can adjust things on his end so that he can be heard better. Maybe you can increase the microphone or...
I just did. Can you hear me now?
A little better.
I'm practically yelling here, so I'll keep yelling.
No, I really can't hear you, Mr. Tipton. I'm sorry.
Maybe I should try to join using a different computer real quick, but I don't want to waste the court's time.
I'd rather hear you.
Judge, can I make a suggestion?
What's that?
Mr. Tipton calls my cell phone, I can put it on speaker and everybody can hear.
How would that be?
Fine with me.
Okay, do you have, I don't need to ask you specifically, do you have Ms. Capiccio's cell phone number?
I don't think so.
Judge, I can share it with Mr. Tipton right now.
All right, very good.
And I'll call in.
Or I can just call you right now.
You can call me.
Mr. Tipton, this is Jim McDermott.
Go ahead, Jim, try that.
Sure.
All right.
Well, here you are.
Can you hear me better?
Hang on 1 second. Why don't you identify yourself for the record?
Larry Tipton for Mr. Walshe.
You able to hear that? All right, Mr. Tipton, we'll hear you.
Just briefly, Judge. I think Liebman, whether it's the government opposes it, but Liebman seems to make it clear it's the Commonwealth's obligation to get materials from the federal government. There's no question when you read those two cases that is exactly what the SJC said way back in the 1980s. Secondly, the Commonwealth has failed to inform this court or any party what the exact basis is that they're relying on that says they can't review the documents in their possession and custody for Rule 14 information as defined by Rule 14. Now, I'll just say that when we were in Plymouth, they produced a December 2024 protective order. There was one they let us read it. We couldn't copy it. We had to hand it back. We did. There is a paragraph in there that seems to touch upon the issue at hand. But that paragraph, and I won't repeat it, but I think the government knows what paragraph it is, and it does not, in our opinion, prevent the government from reviewing the documents under Rule 14. It does have language that says you can't use the materials in any other case other than the Reed matter. But that's not what we're asking for. And for the government to continue to act like a paragraph that says you can't use materials in another case means they can't review them under their obligations under Rule 14 is creative thinking, creative interpretation, and it's simply running away from their obligations. And finally, the only other thing I have to say is what we've said repeatedly, and it was based on what the government told us beginning on July 17th when this issue became known. And that is, why haven't they explained then why Attorney McLaughlin, Assistant District Attorney McLaughlin, did in fact conduct some type of review of these materials and gave certain information to either the prosecutor in their office and our defense counsel. Now, granted, I was never told they gave substantive information, but they apparently gave sufficient information to either their DA or the defense attorney. And that is not addressed, once again, in the government's opposition today. And I have argued that since I was told that on July 17th. And I'll just add that when we were before Judge Ferner, and she read that, and I understand that she cannot rule on this issue because of a judicial conflict, but she confronted the Commonwealth about that very issue. And the government refused to answer. And so I asked this court, why can't the government simply explain that? Why they did it in one case, why they provided information to either their DA or defense attorney in an unrelated case, and why are they simply refusing to do so now based on language they have not produced that, in my opinion, would not justify anything, but they still not produced the specific language. So I understand the court's not going to rule on our motion to dismiss today, but the last thing I'd say is I hope that this court will schedule some type of status hearing no later than next Thursday or Friday. And if nothing else, order the government to stay in touch with the federal authorities and have an immediate update about the status of their motion to intervene. And that's all I have right now, Judge.
All right, thank you. Mr. Tipton, are you connected? You can hear us through the regular Zoom, is that right? I see you nodding your head. Okay, very good. If you want to make another point, jump in and we'll call you again. But I don't want to cut you off. I appreciate the positions. It does seem to me we need another hearing, informed to some extent by what Judge Casper does. Is there other counsel that wish to address the court? I do have one question for defense counsel in the Walshe case. Who's speaking on behalf of the Commonwealth in the Walshe case?
Your Honor, Tracy Cusick for the Commonwealth on the Walsh case.
All right, so I have your response to the motion
Your Honor, a bit of housekeeping, if I could. That was a response to other motions. We received Mr. Tipton's motion to dismiss.
No, I'm sorry, I misspoke. This is a response to the motion for relief regarding federal materials. It's not a response to the motion to dismiss. But in your response to the motion for relief, you say the Norfolk District Attorney's Office is aware of its obligation under Rule 14. It's one of the last lines in your opposition, but you do not say whether you have or haven't complied with it. So I really don't know how you're interpreting Rule 14. How are you interpreting Rule 14?
Your Honor, we are interpreting Rule 14 as it is written, as we understand it to be written, that our obligation is to produce materials favorable to the defense, that our obligation is to, if we're aware of them, to inform the defense of those materials. We are aware of our obligations under Rule 14 in this matter, Your Honor.
But that doesn't really answer my question. We have unique circumstances here. Is it your view that even though these are nominally controlled by the feds, that you don't either possess them or have custody of them?
Your Honor, it is our view that doing what counsel is asking would be violating a federal protective order.
Reviewing the documents would violate a federal protective order?
In conjunction with a different case other than the Reed matter. In this case, we do have the unusual circumstance of someone assigned to the Reed matter is also assigned to this matter. And
so your position is even reviewing the documents, reviewing the documents in this context is not required by Rule 14?
Your Honor, I believe reviewing the documents in this context would be a violation of a federal court
But that's
order.
a different question. The question is, does Rule 14 require you to review these documents?
I don't believe it does, Your Honor, in the current posture of this matter.
And is there anything you can cite to me that would support that position?
At this point, Your Honor, I would say there is currently a federal protective order. We are officers of the court. We are required to comply with that order. And I would suggest it is clear there's the balancing of that federal order and the Rule 14 requirements of which we are aware. In this case, I don't know if the court had a chance to read in detail the Commonwealth submission.
I did.
There have been prior TUI requests by both the government and by the defense in this matter. And again, the court has the response we received from that as well.
The TUI request, though, is a different question than whether the Constitution, Massachusetts Constitution or the federal Constitution or Rule 14 imposes on your office an obligation to review documents that you're in physical possession of. And I don't really, I know that, I don't want to say I don't care, but it's not particularly material to the question of what the Constitution requires of you that a federal prosecutor somewhere said, I wouldn't give it to you independently.
I understand that, Your Honor. At this point, I don't believe we are required to review those materials in violation of the federal protective order. But certainly I would ask for some time to respond to the motion to dismiss that was filed this morning.
Yeah, sure.
And again, if something, for example, if something was in plain view, that might be something that would cause a person reviewing those materials in the Reed matter to bring that to the attention of the federal authorities or to others to say they're aware of information in the custody of third parties. Certainly nothing like that has occurred in this case. No one has indicated they're aware of any materials in the possession of third parties.
Okay. I'll give you an opportunity to address the motion to dismiss. We'll play this out a little longer and see what happens with the motion to intervene and motion for additional relief. I may issue an order in response to this argument explaining why I'm doing what I'm doing. And I'll schedule a hearing for, I think, early next week. I could do the end of this week too. I'm here, but I think the early next week is probably enough time.
I think the order expires on Monday.
The order expires on Monday. That's true. So maybe we should do it before the end of this week.
Could we do Thursday, Judge, potentially?
I have that flexibility, and we should know more from Judge Casper by then.
I could do Thursday morning if anyone could do Thursday morning.
This week?
Oh, Thursday afternoon, sorry. Thursday afternoon, yeah.
I'm on trial.
I could stand it for you, Joe, if you want.
Okay.
Thursday afternoon? Yes. Yeah, Thursday afternoon too, I could do if I'm just trying to give us some time.
Yeah. I'm flexible given what everybody else's schedule is. I think 3 days is probably enough time to get a read, or 2 days. It's only 2 days, but get a read from the federal court as to when they're likely to address, the issue.
Not do, Thursday, Your Honor, but Attorney Scaticcio can stand in.
I'm happy to stand in.
Okay. Mr. Tipton, with a thumbs up or thumbs down, are you able to, do Thursday at 2, even if only on Zoom? That's a thumbs up. Okay, Thursday at 2. Thank you. Attorney Beatty, what do you think?
That's fine, Your Honor.
Thursday at 2?
And Judge, in the interim, may we get a copy of the Commonwealth motion to intervene?
I'm not prepared to provide that at this time. I will consult with our counsel, and if he advises us that it's appropriate, I can do that.
At a minimum, I would like a copy shared with myself and all counsel, even if the content of any confidential information or confidential material has to be redacted from that filing. So I don't know if in your filing, because you're obviously privy to the confidential information, not necessarily you, but others in your office are privy to confidential information.
Not the reason that I'm not sharing it. There's
Okay.
nothing in there that's confidential. That's not the reason.
So if the only reason is that it relates to an impounded proceeding in the federal court, the fact that it was filed in that impounded proceeding, I don't believe entitles it necessarily to be impounded for all purposes.
Again, I'm going to rely on the advice of counsel.
I'm not suggesting you do anything else, and I'm not ordering it to be disclosed right now. I'm taking your representation as to what relief it seeks, and we'll deal with this again on Thursday at 2.
And I think the other concern would be that if we shared it with counsel, what would they do with it as well? I think that's the...
Well, I think we're trying to keep apprised of what's happening in the federal courts so we can make decisions most intelligently here, and so that I don't do anything rash.
No, I appreciate that. I would ask for an agreement that it not be shared or disseminated outside of counsel. That's what I'm saying.
Every piece of paper that's been generated in this issue has had a protective order. We don't have a problem with that, Judge.
Okay.
No objection on behalf of Mr. De Los Santos on that limited, discrete issue.
Okay, and with respect to, so that's Mr. Cataldo?
Okay.
All right, any problem with that, Mr. Tipton?
No problem, Judge.
Yes, no, he's shaking his head no. Okay, very good. In the Walsh matter, I have the Commonwealth's motion for protective order, August 5, production of chats, and Commonwealth's motion for state court protective order covering materials subject to federal court order. Those were signed by prosecutor and defense counsel. I've allowed them and issued them as so ordered, so.
Yeah, and Commonwealth is also submitting for Myles King and for Sean Johnson as well. That's been endorsed by both parties.
Okay.
And I will...
I did make one amendment to the King and Johnson on page 3, in that paragraph saying, because the Commonwealth agreed that I could share the information with my clients, but not the actual document. You can't get a copy of the document. So I made that change on that. I just want to bring to your attention, Judge.
Ms. Hickman, did you see that?
We did, and ADA Beatty saw it as well, and we are in agreement with that language.
Okay, so it would read, let's see.
The defendants are able to view the chats, Your Honor, but they just cannot get copies of the chats that are being produced.
Not duplicate or provide a copy of the text messages to any other person.
Correct.
Okay.
And Your Honor, I will get the printed for Mr. Cataldo and for Mr. Kowski, and I'll submit them by the end of the day so they can have their text message, the chats as well today.
I'm prepared to sign one subject to the same modification, Judge.
Okay.
It was emailed to me, but I was already en route to the courthouse.
All right, let me just act on these with respect to Mr. King and Mr. Johnson.
And I just had one issue I wanted to address before we conclude.
Sure.
I'm not going to be here Thursday on behalf of Mr. De Los Santos, but just so I'm clear of the landscape, I know we're keeping it a short day so we get a better appreciation of what's going on in federal court. But if I understand this court correctly, are you also contemplating an order that would order the Commonwealth to begin reviewing those materials for potential Rule 14 information?
Right now, I'm contemplating an order that explains why I put this off 2 days. I may have time to do that today, and I may not. Maybe not till tomorrow, but I am. So we'll see how far I get on that.
All right.
Okay, but in any event, we'll have further hearing on Thursday. Okay. Anything else?
Thank you,
No,
Mr.
thank
Clerk.
you.
Okay.
There is a protective order on, Mr. De Los Santos related to promises and rewards and
That's
inducements.
with a different DA.
Okay. But Joe, just before we conclude, I wanted to address that today, right?
Yeah, okay.
Oh, right. You're just filing this, right?
Yeah.
All right, can you just identify yourself for the record?
Good afternoon, Your Honor. Jennifer Blair for the Commonwealth.
Okay, and this is in the Chanchillo, De Los Santos, and Johnson matters,
Yes, Your Honor.
okay?
Good afternoon again, Your Honor. Rosemary speaking on behalf of Mr. Johnson.
Okay,
Your Honor, the Commonwealth.
hang on, and Mr. Krowski,
Attorney Krause on behalf of Giovanni De Los Santos.
right?
And Attorney Joseph on behalf of Bianca Tanchio.
All right, and on each of these three cases, I have the Commonwealth's motion for protective order regarding witness identifying information.
Yes, Your Honor, the Commonwealth became aware the week before last, in speaking with a sergeant from the State Police Violent Fugitives Unit, that there was an individual that was involved in assisting them in the apprehension of Mr. Johnson, who they were unable to locate for approximately 8 months after he was indicted. And that sergeant indicated to the Commonwealth that the individual that assisted them with information was given a reward for that information, a monetary reward. The Commonwealth asked the sergeant for the particulars surrounding the circumstances, who the person was, identifying information, how much money, et cetera. We asked them to reduce it to writing. That was done. It was provided to me yesterday afternoon, and the Commonwealth is prepared to provide that information to counsel. However, contained within the information is the fact that that individual is in fear for their safety if their information is to be disseminated to individuals other than the attorneys. And therefore, the Commonwealth is asking that the information be provided under a protective order and limited to the information to the attorneys themselves.
Okay, you've seen these motions?
Yes, Judge.
Okay, is there an opposition to the motion?
I do object on behalf of Mr. De Los Santos.
Okay.
I would, subject to the court's approval, meet them halfway. I think that my client being charged with with homicide is entitled to know who is accusing him or so-called co-ventures of what. I, at this time, would agree not to share the actual hard copies of the paperwork if there's any concern about dissemination with any facility. However, for him to prepare for his own defense and participate meaningfully, he has to know who's accusing him or his co-defendants of certain conduct. I would imagine that the government, and they're being tried together, is going to try to use this information as potential consciousness of guilt. That name probably will mean nothing to me, but might resonate with my client. It might be a person that he has problems with. It might be a person that he has specific firsthand information of as it relates to bias or credibility. And again, if you look at the pleading, it is deficient in that it's only a very generalized assertion that the witness has fears for their safety. I would imagine, having done these cases for many, many years, that if you poll just about every civilian witness in a first-degree murder case, they would express some sort of generalized concern for their safety. There's nothing laid out in affidavit giving an individualized, particularized assertion of why they're afraid for their safety as it relates to Mr. De Los Santos. So again, in the spirit of compromise to move the ball forward and have my client, who's got idle time on his hands, participate in his defense, I would agree not to share the actual documents with him, but I would ask that you allow me to bring the documents and review them with him when I meet with him.
So I join in what Attorney Kowski says, but I have a bigger issue, which is another issue we're dealing with in a separate case, but where has this information been for 2 years? How did the Commonwealth just get it last week or the week before? How have they not gone through the file and determined what evidence they have? Why are we just finding out about it now? And that's my concern, Judge. So I'm going to ask that you order the Commonwealth to file certificate of compliance in the Johnson matter, so that we are sure that we have all of the information, that the Commonwealth has done their job, that they've met with these people, and that we're not going to keep doing this where we can't schedule a trial date until we have a certificate of compliance to understand what's going on here, Judge.
I would join that request and ask that it lay out specific dates of when each piece of discovery was turned over.
Attorney Cataldo?
Yes, I too object, Your Honor. I think the defendants are entitled to know who their accusers are and who witnesses are and who people informants might be in a circumstance like this. To the extent this court were not to allow it, I'd ask the court to at least do it without prejudice, so that after we find something out about these individuals, we can come back before the court to then see if that's something we should share with our clients. Because ultimately, it is our clients who may or may not know these individuals and may or may not know the relevance of these individuals to the case and to the defense.
All right.
We shouldn't be operating blindly.
Attorney Blair, defense counsel are giving you a range of other options you could fall back to.
Your Honor, what I can say is that it is put forth in the motion. The state trooper did speak to the individual who expressed their concern. And Your Honor, this is a witness who assisted in locating Mr. Johnson. It is not, this witness did not make any statements about any of the other co-defendants or about any of the merits of the case, just merely the location of Mr. Johnson.
How do we know that, Your Honor?
Oh, the, how do I not allow counsel to communicate with their clients about a witness who's going to be testifying or might testify, or they even might call to testify with regard to a matter relevant to the case? Well,
Your Honor, the Commonwealth will not be calling this person to testify. It was 8 months after the case. It was merely a location. Your Honor, I would submit that that counsel could review the information. The Commonwealth will not be calling this witness. Counsel can review the information, and if they determine that this is somebody that they would want to call, they could come back to the court and ask for the order to be modified. The Commonwealth is concerned that there is a significant safety issue for this individual if the identifying information is revealed to their clients.
But Judge, I guess I'd ask with respect to Mr. Johnson, what's the safety issue? Other than generally he doesn't want anyone to know that he got paid to give up Mr. Johnson. I understand. But that's not enough of a reason not to allow Mr. Johnson to investigate this, because what if it affects 4 other witnesses in the case? I don't know that, but I don't want to be in a position where I have a trial date and I'm finding out on the eve of trial that this witness, who they said was nothing, ends up being way more than that, Judge. And we can't make that determination without sharing the information with our clients.
The witness assisted the state police in locating the defendant years ago, right?
Yes.
The promise, reward, or inducement was paid to that person years ago.
Yes.
So all of this information should have been turned over to defense counsel years ago, right? Presumably, you know, that's the first promise, reward, and inducement paid by the police in connection with this case, presumably. I don't know, maybe there were others. And there's no suggestion that there's been any issues with respect to this person. May not be known to the name, may not be known to the defendants. Or maybe the defendants have had some suspicion, or Mr. Johnson has had some suspicion but hasn't known who it was who called the police about his location. I don't know. Where was Mr. Johnson apprehended? California?
New York.
New York?
No, he was not, no.
In Massachusetts?
In Massachusetts, in Webster, Massachusetts.
In Webster, okay.
Sorry, Judge, I apologize.
All right.
That's another case.
All right. Okay, I'm going to allow the motion for protective order, except that the name of the person can be shared with the defendants. Any documents containing the name or address or other identifying information, that any written documents, okay, will not be shared, but the name can be shared with the defendants.
Thank you.
So these motions will be allowed, except that the name can be shared orally, okay, with the defendants. And that will be without prejudice to renewing a request for further disclosures if necessary.
Thank you. Want to hate your claim?
All right. Now, anything else that we need to do on this cluster of cases, this 3 Code D case or the others?
I would just ask on behalf of Bianca Ciancio that she'd be excused on Thursday. Attorney Scott Pichu is standing in. She's out on cash bail.
I'm happy to have any of the defendants who wish to be excused on Thursday. I don't know if either of the defendants who are here in person want to be brought in again. I know it's a hassle to be brought in, but if you want to be brought in, we'll bring you in.
It seems to me they both have said yes.
They both, yes.
Santos wants to be.
Okay, Mr. Johnson would like to be here.
Okay, fine.
And Mr. King is out on bail, and he'll definitely be here.
Okay, very good.
One last issue.
Yes.
Judge. I had filed motions last time with the court, and he was then subsequently interviewed by probation. Sure whether or not he qualified.
All right.
And you were just waiting
On,
authorize those motions subject to that interview and evaluation.
have that information? Okay, all right.
De Los Santos?
Yes.
I'll take a look at those motions for funds.
I'll look too.
Okay,
Maybe.
thank you.
And then just do a separate matter with Mr. King.
That's correct.
Yes, we do.
Judge, just while I'm waiting for everyone to come in and out, Christopher Rando, Mr. Nelson, and Mr. Amanu.
Okay, thank you.
Thank you. It's on for, Mr. Rando, you're good right there. Could I just have counsel identify themselves for the record, starting with the defense attorney?
Good afternoon, I'm David Arnold, John Nelson for Mr. Rand.
Thank you.
He's present in the back. Sean for pretrial conference.
Sir, you can be seated. Okay,
So, and speaking, I believe I have all the discovery other than the drug file.
okay, so we're just waiting on that.
We're going to request the date of either the 14th or 15th of October for pretrial hearing and filing of any motions. I think we could.
Do you anticipate any motions?
Maybe a motion suppression.
Maybe.
It was a motor vehicle stuff.
Okay.
I think 10:15 works better, if that's okay. 10:15 at 2 p.m.
Is that okay with you, Mr. Amanu?
Okay.
Great.
Thanks, 2 p.m. Thank you.
Thank you.
October 15 at 2.
Thank you.
Thank you for your patience.
Thank you. Thank you.
Thank you. And now we're back on the Myles King matter.
Thank you, Ronald.
Good afternoon, Your Honor. Michael McGee for the Commonwealth.
Okay, Mr. McGee.
Good afternoon again, Your Honor. Rosemary speaking on behalf of Mr. King.
All right.
Good afternoon.
Nicole Capucci on behalf of Mr. King.
Okay, Mr. King is here.
Good afternoon, Your Honor. Dan Moynihan on behalf of
Mr. Moynihan.
I filed that amendment motion, late this morning.
I saw that, yes. So I was given a piece of work product, page 1 of 36,
Correct, Your
which
Honor.
looked like well, you tell me what it is.
So, Your Honor, you gave us, or counsel, 2 tasks. One was to provide a list of all new discovery and any disputed, whether it was new or previously provided.
Yep.
In a joint form. That is what you have before you. You also asked counsel to identify which of those documents were exculpatory or items and information favorable to the defendant that you do not have.
Okay, so let me just see if I understand this correctly. And I didn't have a chance to compare this earlier against the notices of discovery, but let me just take a look. So you start with notice of discovery 26, and these are numbered 1 through whatever it is, 8, because there are 8 things in the notice of discovery 26. You've listed the description, which is the same description given in the notice of discovery, as best as I can see. And then there is an agreement on the right-hand side. If it says why, you both agree as to defense notes, which was it that was not previously produced. Okay, if there is a no in that last column, it indicates that